Mr.
Yes.
Perez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine.
All right, let's paint the picture. Perez is staring down jail time for a DWI charge and is currently out on bond. But here's the twist. He skips court. And when that happens, you know the dominoes don't just fall. They crash down hard.
So, correct me if I'm wrong, but he was out on bond on this case, right?
Judge, I'm not.
Yeah,
Not sure
we
about
gave him
that.
a general bond and he failed to appear. You know, Mr. Perez, we gave you a free bond and you got out there. All you had to do was come back, and when you come back, good things happen. I want you to listen. Your failure to appear, we issued a warrant, we revoked the bond, you ended up going back to jail, and you spent enough time to where immigration was able to put a detainer on you. That's why you are stuck in there now. For future reference, when you pick up a criminal case, come to court because good things happen. Had you come back, it probably could have been resolved in a good way for you. Do you understand?
Yes.
You also need to understand that what you're doing now is you are pleading guilty to the offense of driving while intoxicated.
We're actually put you on probable cause.
Oh, you are? Oh, I thought you were pleading to.
Judge.
Oh, my fault.
Well,
Well, it may end up good. I don't know.
Actually, once he was detained, he was taken to immigration almost immediately.
Oh, really?
The GOP bond, Judge.
Okay. I thought he got out. You sent to immigration?
Yes, he was denied bond and he was
Got
returned.
it. Okay, well, he got a bond, I guess, because of the GOB.
Correct.
So you don't think they're PC?
I don't think there's probable cause in this case, Judge.
Do it up.
Yes, Judge. On December 16th, 2024, at approximately 12 a.m., the officers were stationary on West San Houston Parkway when a prohibited vehicle alert displayed a gray Mustang that was prohibited on the toll road. The officer observed that the vehicle was prohibited since August 25th, 2024, and owed $1,536 to the Harris County Toll Road Authority. The officer initiated a traffic stop. Upon contact with the defendant, who was the driver of the vehicle, the officer observed a strong odor of an alcoholic beverage, red glossy eyes, and slurred speech. The officer observed the vehicle to be registered to the defendant, and the defendant admitted to drinking. Stanfield sobrieties were conducted, HGN 6 out of 6.
Hold up for a second. His BAC came in under the legal limit, but the officer insists it would have been 0.08 earlier. Really? That's a shaky call. Probable cause is one thing, but this could be the exact hill worth challenging.
Can turn 4 out of 8, one leg stand 3 out of 4. The DIC was red and the defendant considered a breath. The results were .067 and .065. And the officer further stated that the defendant's BAC would have been .085 at the time of stop. And that was whatever that, yeah.
Okay. So what's your argument?
So Judge, my concern is that it seems like the police officer has some type of suspicion that he was intoxicated, asked him to do this FST.
No.
Yes,
The
Judge.
stop was initially because it's a prohibited vehicle, right? You owe a crap load of fines and fees to the toll road. You're not supposed to be on the toll road, right?
Right. But I mean, in regards to the DWI, Judge, I mean, he asked him to do SFSTs, he conducted those, and he doubled down on his suspicion and asked him to do the breathalyzer. An hour and a half later, he blows under the legal limit, .065. That's significantly less. Now, it's the cop's suspicion. Now, at that point, he uses speculative reasoning to believe that it was a .08 at the time that he was driving without any type of scientific method or any type of legal actual scientific basis.
Remember, this is probable cause. We can't get into the facts to whether he's guilty or not guilty, whether he's really at a .08 at the time of driving. I don't know, but that's why we have trials, to give them the opportunity to respond to what your argument is, because they can't possibly do it now, you know?
I guess my concern is that if you look at the circumstances in totality, I mean, it seems like if the police officer was doubling down on his suspicion, asking to do a breathalyzer, and he passed it, at that point, the other exams were basically just a physical test instead of actually a test for intoxication.
And you may be well right as far as beyond a reasonable doubt. but this is just a probable cause to see if we go forward. Set the case for trial.
Yes,
I think, it would be a great trial.
In that case, Judge, we would ask for the earliest trial.
Yeah, but here we have a good stop,
Yes, Judge.
smell alcohol.
Yes, Judge. Then glossy eyes, and then also, I apologize, let me pull up, and slurred speech. And then after
We've got
that,
all the indicia to begin the DWI investigation, right? Did they do any SFSTs?
after that, they did SFSTs, and they had 606 HGN, 4 of 8 walking permit, 3 out of 4 one-leg stand.
Right. So I think that there's enough just to go forward for probable cause purposes. Now, set it, you may be right as far as they make, it's good for probable cause, but it may not be enough for beyond a reasonable doubt.
Sounds good.
I have to give them we got to give them 30 days? So we can set up a trial in 30 days. Be ready, watch the videos just to make sure, it coincides and
Just to understand, I have to wait 30 days to set it, or I
no,
can?
no, no.
Now,
Let them know now so that they can get their ducks in a row as far as subpoenas and all that, and is what discovery's in.
Yes, and it's completed, yes, you have. We're just missing station video, but everything else.
Okay, that's a big part, because you're gonna need that as far as breath testing and stuff. So, just stay on top of it. If you want to set it now,
Yes, Judge.
and if you want us to get a couple of weeks just to see if you can get the video,
I think we'll-
whatever you want to do.
Judge.
Okay, just let Victoria know.
Thanks, Judge. Have a good one.
Hi, good morning, Mr.
I
Lee.
have Mr. Khalifa. He is in custody. And
Okay, right?
yes, with the K.
How's Mr. Khalifa?
He is,
I can. It's just,
he is very adamant. Say that.
yeah,
So
it's an understatement, right?
his felony attorney, I actually know his attorney that's on his felony, and he was here this morning. And I was talking to the chief, and at this point, it would be time to set these for trial.
Okay,
And
it's up to you.
the they're asking for 2 weeks to talk to felony to see if they want to dismiss it. But if it does go to trial, I'll need an Arabic interpreter to review evidence, and I think also.
Are there videos? Hold on a second. Whoa. Have you looked at the discovery?
Yes.
Is there stuff in Arabic?
Yes,
There is stuff in there.
Okay, so you got to go get all that stuff. Hey, they're saying some of the videos are in Arabic.
For the text.
Right,
The text.
but
So-
you need the prosecutor.
Remember, we need at least 45 days just to translate that video into Arabic.
Right.
So get on it now. Are you going to go to trial on this thing?
If they don't dismiss it, I am.
Okay, so can you send it to you need to transcribe it in Arabic. That takes at least 45 days.
Right, and we just have 188 in our office that speaks Arabic and he has his own document.
No, but they send it out. But you got to put in the order now,
Yes, sir.
if you don't mind, please. Okay, so,
If they don't dismiss it, we have no reason not to go to
yes,
trial.
hey, look, what I'm saying, let's get the order in now.
Exactly.
Because it takes 45 days. That's why.
Well, they may dismiss, but. I don't know.
And May is a big,
I understand.
I want to make sure that gets done so he doesn't languish in custody because
Exactly.
we can't go to trial until that video is
Well,
transcribed.
no bonded on his felony, and that trial date's October 9th.
Of next year.
Well, this year now, 2025. Yeah.
They set a trial for October of this year?
And he has no bond in the 179th. So.
I have a trial in October, so go on felony. It got set last month.
Should we just get a trial date out, maybe 2 months?
No. Let's just make sure the stuff gets done. Because when you set stuff out that far, they tend to not look at it because they're just so busy. It's better to just keep little settings so we know that we can get on
Could I
top
do
and
like
stay
a
on top of it.
2-week reset and then we'll.
Yeah, you want to eval it too?
Yes, sir.
Yeah, set it 2 weeks, eval it,
Okay.
and then if it's good for you, start putting the video in to get transcribed. Because he says he's going to trial unless you dismiss it, so, yeah, okay? All right, Grisham. Hi,
Need to get more Arabic speaking cases. Sorry.
that would be an interesting case.
Yeah.
Anyways,
All right, Your Honor, I got Mr. Kabir, who's in the boxes for PVR. I have a feeling you're gonna want to raise bond or do something, so
come on, Mr. Kabir.
if you were leaning towards that, I would like to request a hearing and have a record on it.
Sure?
But that's only if you want to raise. I hope you don't.
I mean, he tested positive. I've asked him not to use. I've asked him not to consume anything illegal. I've asked him not to consume alcohol. He's still using, you know?
Your Honor, it was, I spoke with pretrial, if, just hear me out for a second.
Sure.
Spoke with pretrial, it's presumptively for THC, you know, things like Delta 8, kratom.
Now it's strike 3, his third bond violation. Here's the real question. How many chances should someone really get before the judge finally says, that's it? What do you think? Too much leniency, or just a judge giving one last lifeline?
Those are all legal.
I admonish him over and over. This is our third bond violation. If I let him go, I'm enabling the behavior, and I'm saying that it's okay to happen. It's a third bond violation, Mr. Kabir. I'm setting you for a hearing in 3 days. You must be here, be ready to go forward. Do you understand? I can't continue. It's a third bond violation. It's unacceptable.
Understand. And look, I appreciate you giving us a little time for the hearing. I also, and I was here yesterday as well. We are looking like, it looks like we're about ready to set this for trial anyway. Do you want to wait till the hearing?
If you want to set it, you can, but I'm requiring his presence in 3 days here to have the BVR hearing.
You said 3 days or 3
3
days?
days. No, 3 days.
3 days.
So that you can get all your ducks in a row, get all the evidence you need. State, get ready, please, as well.
Yes, Judge.
But, you know, if it was a first, we admonish. Second, sometimes, okay, we're now at a third time.
Yep.
No. Yeah, okay, I'll see you in 3 days. If you ever miss again, I will issue a warrant for your arrest. There's absolutely no tolerance in the future. Do you understand?
Yes, sir.
Court orders are court orders, and you don't just evade and decide to do what you want to do. Do you understand? You were ordered to go take a test and you failed to go take a test. That's the rub. I'm sending you now for a test.
Sorry, so he has ordered to go get a drug screening test and he did that. They have the results back.
When did you go take the test?
January 16th.
16.
Judge, it shows that it came back positive for THC. Confirmed by the lab.
Oh, I see. Okay. No more. No more using. Do you understand? I'm going to test you 50 days from today. If you test again, I'm going to put you in custody.
Yes, sir.
You understand?
Yes, sir.
Okay.
Oh,
All right.
sir.
We got you guys. We'll set you off for 50 days.
So Judge, at present, Mr. Jones has both a scram device on and a GPS, and he's on a curfew. He's broken curfew a few times, Judge. If you look at the times, though, it's because he's leaving a little early and getting home a little late. The latest maybe being half an hour past curfew. Mr. Jones has maintained gainful employment. He's worked as a helper for a transport company. He's not driving, he's the helper. And so he gets on the truck with the driver, he helps, and then they get back to their site. His wife picks him up from work, and then they pick up their grandkids, and then they get home. He's driving from the east side of town, across the ship channel, down 610 West, and then all the way to 90. Into Crosby. It's a long commute. And so due to all that, and his employment is working with him right now. So they typically wouldn't be done at the times they're done, but to keep him on, they're trying to make sure he's done by a certain time so he can make curfew, but it's just a tough commute, especially when he's not the one driving and they have to pick up children because there's only one person that can drive. But he is only late and he only leaves early because of work. That is his only.
You have to understand, you have 2 open DWIs, so it's absolute strict compliance. I never want to ding anyone for working, right? I want you to work because I think that, you need to work. Number one, you need to make money, and it gives you something to do so you don't become more self-destructive as it is. I see the violations here. We have no alcohol violations, correct?
Correct.
Okay, that's good.
Joshua or?
Joshua Jones, do we have any alcohol violations?
I have no problems now, Judge. Trust me.
I don't see any previous violations, Judge.
Okay, so it looks like most of the stuff, I would tend to agree with you that, upon further inspection, it looks like it may be a little bit here, but there, but prior to. Is all this work related?
So
Okay, so what time do you leave for work in the morning?
I normally have to be to work at 7,
Okay,
most times.
because I have here that you leave one time here at 5:56 in the morning.
So
Why that early?
like I say, most times is anything that I'm leaving is work related. And one of the things that I've been trying to do since I got out was maybe to get in contact with my lawyer to kind of help me out and
But you're not getting in touch with your lawyer at 5:56 in the morning?
So just because it's a transport company, those jobs have different timelines. They are aware of the circumstances, so they try to tighten up on those timelines. But if they have a job and might need him one day at 6:30 or something like that, that's when he'll have to leave early. And he's afraid he's gonna lose that job if he can't comply with what they're asking of him. So I'm asking today, Judge, if we can loosen the timeline a
I'm
little
okay
bit.
with tweaking the schedule,
Okay,
but I want to do it in a real, I'm not going to give you too much leeway. We have to be reasonable about it, right? So I need a time that that's early enough that, you're not going to violate anymore because I don't want to continue to do this, right? So what is a reasonable time in the morning for you to leave?
to if he would have asked me to get to work between 6 and 6:30.
How far is it from home to work?
It's maybe a good hour, 10 minutes if it's bad traffic or weather.
What about coming back home? What's a reasonable time?
It's not.
I'm not going to do 9 o'clock. I'm not going to do 9. I don't want you out that late. I will give you a little bit of time after 7 o'clock, but 9 o'clock is too late. When you're coming home here now, you're coming home at the latest at around 7:30. I'm willing to give you, 7:45, 8 o'clock, but that's the latest I'm going to give you.
8 o'clock is fine.
Okay, so Jillian, we'll tweak it 5 in the morning to 8 at night. If there are any more issues, I'm going to lock you up. I mean, I'm working with you now. There should be no more issues. I want you to work. I just don't want you drinking, and I don't want you out in the middle of the night because nothing good happens out in the middle of the night. And I definitely don't want you driving. Do not drive. I don't care what circumstance comes in your life. Do you understand? I'm really going to hit the roof if you drive. Okay. All right, Jillian.
thank you,
You
Judge.
got it. Good morning, Ms. Claus. So it's come to my attention that you have not signed the waiver. So there's 2 options that we have here. You can ask for a bond or you can waive extradition. Once you waive, we give the demanding jurisdiction 14 days to come pick you up. In this case, it's Orange County, Florida. That's where you're wanted out of for grand larceny in the 3rd degree.
For what, sir?
Grand larceny in the 3rd degree.
That means grand larceny.
Larceny is it's a theft.
3rd degree is.
As far as, I'm just telling you what they wrote on the actual, on the complaint, it says not grand larceny, grand theft in the 3rd degree, $5,000. That's what it says. So if you do not want to waive, that is okay. The waiving, it speeds up the process because we only give them 14 days. If they don't come within the 14 days, Harris County releases you. You got to understand, even if we release you, that warrant from Florida will always remain active until you go back to Florida and take care of it. If you refuse to sign the form, that's okay. We will get a governor's warrant, but that takes 90 days. So you're going to sit here 90 days waiting for that governor's warrant to hit. So I will let you make the decision with Shabli, what you would like to do. I don't want you to make a decision here in front of everyone. Take your time.
She does want to waive, and they were going to give her the credit for Friday when she was originally booked in. They were going to backdate it to Friday.
Well,
Here's the kicker, though. I just noticed you have an open felony theft case, and you've not made bond on the case. So what happens is that 14 days is typically told until you resolve that case or until you post bond. When all the holds are lifted, at that point, that triggers the 14 days for Florida to come get you. So,
I didn't know you had a case. a
yeah,
local
I mean, I
case.
just noticed it too. So, you can still waive now so that once that hold lifts, it kicks in the 14 days. So, well, I'll let you guys talk about it and let me know.
Yes,
Yeah.
thank you.
All right.
Okay, I'll get the
It's close.
paperwork to you. It just doesn't come into effect until you handle the paper.
So Shabli, if she waives, there's no need to bring her back out. We'll just sign it and then I can sign it and then we're done.
Yes, yes.
Working on Mr. Jonathan Joyal. It's a young man with 2 cases in your court.
Okay, tell me what's going on.
So here's what's going on, Judge. My understanding, and we're trying to confirm from upstairs in felony, is that he's going to WIMAC based on the new violation in your court of a UCW. So that's causing him to be amended up there and go into WIMAC. That being the case, he's currently in custody. He's only going to be released to WIMAC. So at this point, I'm trying to see what kind of options we have for him. I wanted to come to you to see if he doesn't want to plead to this, how quickly can we give him a trial date if he wants to go forward on these cases?
Alex, do we know 100% that they're going to amend and go to WIMAC?
The only note that I have from the prosecutor in felony is saying that the defense told him the defendant is willing to go into WIMAC, but I don't see any clear indication that that's what they're going to do.
The research I've done.
It happened.
The research I've done on the system and on some of the notes on my end, I don't think they could see it, but it says release to WIMAC only. I looked at the activities up there, and based on all the research, it looks like he's going into WIMAC.
You see, maybe I can see something.
I talked to him as well.
Well, I do see on the same day that note was placed, they dismissed the MAJ and just said that there was a condition amended, so it may be that.
It should reflect in the notes somewhere. I can't imagine that one of the
It left
prosecutors is
explanation
gonna.
blank on the motion to dismiss.
Well, no, not, I get it, but don't y'all have like a independent notes to, I mean, every time something happens, you guys should notate what
Yes, Judge,
happened.
and the only note we have is says that defense counsel stated the defendant is willing to go to WIMAC to stay on probation. And then they followed that with a dismissal. So I'm
I
imagining.
see it. No, I see
You
it.
see what I'm talking about?
I see it says, so like I have here 131 amended conditions of probation order, release defendant to WIMAC staff only.
That's what I got as well. That's
Okay.
mine.
Kelsey, what do you want to do with this case? Because we have these 2 UCWs. While these are open, we can't do.
1 UCW, 1 evading.
Right, I emailed them, Your Honor, and I mean, I need to have confirmation. that
Have you
it's
put an
done.
offer on this case?
Let me look.
Because maybe you can work something out today. I don't know.
He does, I talked to him. He doesn't want to plead to it.
Oh, but then if they don't want to plead to it and they're not willing to dismiss both, we'll have to set up a
And
trial.
that's why I'm touching base to see how quickly we could go to trial.
You need at least 30 days.
Okay.
So they're going to need at least 30 days to get subpoenas out. So
Week, right? I lose a week. If we're going off the 30 days, I'm losing a week just by agreeing to this.
no,
Okay.
for that day.
All right, let me talk to my client and see what's going on. Okay, thank you.
Sure.
Thank you.
Do you want to talk about something else real quick?
I have one other one, and here's the,
Okay, great.
since she signed the waiver, we're gonna set her bond at 1,500 for the silence.
We're setting the bond at 1,500, right? For,
Gonzalez. Cause she came and gave this to me after she signed, but she didn't reapproach with you.
yeah, she didn't say definitively whether. Yeah, of course I wrote it on the docket and I'm assuming that because she filed that we're going to set the bond at 1,500.
What is it, a withdrawal?
Yeah.
Yeah, it's a
Well,
wait.
yes.
Yeah,
If they're-
okay. On Patterson,
Yes,
540.
Neosha Patterson.
Alicia Patterson, yeah. This was on last,
8810.
it's set for April 3rd.
Yes, I just noticed, I didn't get a chance, you ought to have read the probable cause before I got in here, Judge. But I noticed that, I don't think it meets the probable cause. I was gonna see if we could read it.
Yeah, absolutely. So, oh, you want to do a probable cause hearing?
Yes, we can.
Okay, absolutely. Please.
All right.
Did you get it? The cause number?
Yes, what is it, criminal trespass, is that the one we're on?
Yes.
January 24th, 2025, Leo dispatched to apartment regarding family disturbance. Law enforcement officer made contact with complaining witness and former dating relationship with defendant. Stated defendant has been banging on door of her apartment since 1/23/25.
Yeah.
Defendant did not make any threats or say anything besides banging on the front door. Law enforcement officer observed defendant moving around rear seats of complainant's motor vehicle. Complaining witness approached her motor vehicle, claimed ownership, and ID'd defendant as person inside. Complaining witness stated she had recently got a motor vehicle, had not let defendant borrow a motor vehicle, or use it in any manner, and also stated that she secured all the seats. Defendant stated motor vehicle was already unlocked and law enforcement officer did not observe signs of forced entry.
So just for trespass, you gotta either have been warned before, don't come around here, we don't want you here, or you're there and then you're told leave and you don't leave. So this doesn't fit either one of those. I mean, the door's already unlocked in the car. She's never been told not to go in this car, stay there. In fact, this is the lady that the complaint witness was here.
I remember that she was here.
They stayed.
They have a bit of a history together as well. I think there was a prior where the complaining witness.
So the trespasses were with regards to the car.
Yes.
Okay. Did the complaining witness tell her to leave and she continued to stay? Or was there some kind of notice prior that, hey, you know, I don't want you here, or go through it one more time, will you?
She did not let her borrow it or use it in any manner.
She just took the car?
She was just in the car.
She was just in the car.
It was cold that night and she was trying to get in and, I know this isn't here, but the complaint witness told me that she didn't hear the initial call, initial knocks on the door. It was later when she reviewed the Ring camera that she saw her at the door since then, but she heard at the last few, the knocks or whatever. And that's when she reviewed the camera and then called the police. But I think it was more of a situation that she wasn't sure about her mental state. I know this isn't here either, but that's what she told me.
Right, but we can't get into the facts that are out because that's not fair to them, right? Well,
She shared with one of the prosecutors, he's not here today. I forget the young man's name. And talked to Shisley with him.
Oh, with Alex?
Yeah.
He did speak with her. Absolutely.
So did she tell her to get out of the car?
Well, she didn't let her in her house, which.
Right, but she's charged with the trespass of the car, right? So did she, at what point?
No, but she did go out of her way to say that she has never let her use the car, never borrowed it, let her borrow it in any manner.
So she's just in the car when the cops roll up?
This fact pattern, yes. That's what I understand, having not spoken to the complaining witness myself.
How did she know that she's not supposed to be there? Because from what I understand, they're in a relationship.
Well, prior dating relationship.
How much former?
Not sure of that, Your Honor.
Is it something where you broke up 6 months ago and you know you're not supposed to be in the car, you know? Or is it something where it's?
There was a previous charge against the
I mean, let's look at the statute. Hold on.
defendant for stabbing the complaining witness. So
Say it again.
there's a previous charge against the defendant for assaulting the complaining witness. So I would imagine that there's not supposed to be.
Remember, we don't work on hunches, right? It's got to be
Yes, true.
definitive. Texas Penal Code. No.
It's 30.05, I guess.
A person commits an offense if the person enters or remains on or in property of another, including residential land, agricultural tract, recreational vehicle, park, a building, had noticed that entry was forbidden or received notice to depart but failed to do so. Did she have noticed that entry was forbidden?
Doesn't appear so, Your Honor. They had been broken up for a couple of weeks at this point. I do.
But Harold, you know, if you're broken up, you know or should know that you're not supposed to be there, right? I can't just go to someone's car, enter the car. I know it's cold, but that doesn't give me the authority to just go in someone's car and sit in it, right?
Well, it was cold outside.
I don't
She knew it
care.
was her
Even
car.
if it's 100 degrees, you can't just go into someone's car, you know, and just stay there as justification for criminal trespass. You know,
Well, but I mean, we're also justifying the state filing these charges, Judge, by them not having the complete amount of the facts and here the elements. You know, as far as, just like you read, like I said at the beginning too, the no notice entry was forbidden or
well, no,
receiving notice.
but if you're broken up with someone and you're no longer in a relationship, you can't just go into that person's car and assume that you have authority to go there, even if it's 2,000 degrees below Fahrenheit or Kelvin, right? it just doesn't, it doesn't jive. It doesn't make sense. I don't think that that would be a reasonable interpretation, you know? If they were in a relationship, in a current relationship, then I think that that would be reasonable. I think that that would be okay where you could go into there. But if they're not in a relationship anymore, I think that that would be, I don't think that would be reasonable, you know? If you show me something different, then, and I'm all with it, right? But you know, or you should know at that point, you can't just go into someone's car.
I understand, but I did check the report too, and the report mirrors this exactly. So they've got no other evidence, so they might even.
Well, Judge, she hadn't moved out, so she had taken her stuff and moved off the premises.
She had moved on.
She had moved out over a month ago.
Right. So that's what I'm saying. That adds credence to that. You can't just go into someone's car. I know it's cold. There are other places that you can go. And I don't think that that's a reasonable justification
Yeah, the month
violate.
I understand the month facts are coming from the report, and in that report, she does tell the officers, "I still have stuff in there. I live here." You know, my client says that, but we might be able to work this out. I understand.
Right. But nevertheless, they had broken up. She moves her stuff out, and she may be saying that to the cops, right? To be able to not get arrested, right? But what we have here is that they're no longer in a relationship. She's moved on. And yeah, I think that there's enough, you know?
Yeah.
Sorry, Harold.
Thank you.
Okay. Close.